Okay, this is for first Shlema for all Cholim of Klal Yisrael.
Amen.
Okay, Halacha we're going to be discussing was related to Halacha is watches and clocks. Electronic clocks. One may wear an electronic wristwatch or a digital watch, or even probably one of these smartwatches today, but one may not adjust the controls of a watch or clock, like these digital alarm clocks as well. One may not wear the type of watch which displays the time only when a button is pressed.
So that's a smartwatch. You should be careful of the smartwatch.
If the time is constantly displayed, yeah. But the watch has the capacity to display other functions at the press of a button, then the watch may be worn, but only if one is certain that will not press the button. Okay, let me just read that again. If the time is constantly displayed, okay, yeah, like smartwatch, exactly, like smartwatch, and and most digital watches you didn't have to do that, but it applies to a smartwatch today. So you just don't push the button. That's it. You can wear it. That's it. Then mechanical clocks and watches. One may alter the hands of a mechanical watch or clock, but they may not be wound up. Automatic self-winding mechanical watch may be moved and worn, but if it is seen to be operating, non-electric alarm clocks may be used if the alarm has been set and wound before Shabbos, so that only the necessary action on Shabbat is pulling out of the button. Okay, well, that doesn't really apply. Basically, don't touch the thing. That's it. Bottom line, don't touch anything. Set it along. Don't put it out of reach of your hand. So if you have an automatic action like a weekday where you switch it off, put it slightly away from reach from your arm span.
Let me just add something. I did some research on this. You can use what's it called, the watches that I think you mentioned that one that are kinetic or whatever, that you move your hand up and down. Those are allowed, and I think it was covered there. But the other one that is allowed is the solar watch. I bought one and I'm in trouble. Yeah, you can use the solar watch because of the fact that it doesn't require a charge on that Shabbat. It actually lasts 3 months. So because of the fact that it's not requiring a charge, even though it's picking up sunlight, the watch would still stay on even if you put it into a cupboard. That's the rule. That's the litmus test. You put the watch in a cupboard and for a whole day and it still stays on. It means it's not reliant on the sun.
No, as long as you don't adjust it, I think that's the main issue. Is adjusting it or like.
Yeah, listen, we need to speak to some of the rabbis. I'd like to get an update on this because it's
because maybe you.
It's something I want to look into. So just the message to finish with Kevin, during COVID times, just watch you don't get clocked.
Watch out, yeah.
Watch you don't get clocked, yeah. Clocked out, yeah, exactly, clocked out.
Clocked out, yes, actually.
Yeah. Guys, I need to... All right, guys, we're going to carry on with the Gemara. Appreciate your patience for everything you've always done for me. I really appreciate it. We're on 48b2. The Mishnah states further, if a homeowner's father or his son was in the cistern and was killed by the falling ox, the trespasser must pay the kofir reparation. So this is a little strange. Why? Because the Gemara is wondering, why must he pay it? The ox is presumed to be classified as a tam. And when a tam kills a person, its owner does not pay kofir. Okay? Let me explain to you why it would be a tam. How many cases do you know that an ox kills a person by falling into a pit? Do you think it did it 3 times? Do you think if an ox fell into a pit 3 times, it would, yeah?
It's like a hypothetical, probably more hypothetical than actual.
Yeah, so, well, that's exactly it. You must know, that's exactly the point. That's exactly the point. So, it's although it's hypothetical, we say, well, how do you know that it's such an unlikely case that, exactly as Kevin said, the Gemara says, well, what do you mean fall? Firstly, would it survive 3 times if it fell into a pit? That's number one. Number two, how habitually does an animal keep falling in a pit 3 times in a row? You know, and then you're dealing with an issue of intention. So the Gemara says, look, the first 3, these are the possible explanations. Rav said, here we're dealing with an ox that is muad for falling onto people in pits and killing them. So apparently it's already killed 3 people in this manner, thus becoming a muad for doing so. The Gemara understands Rav as meaning that the ox intentionally threw itself onto people in pits 3 times. Guys, let's just go with the flow. I don't understand if the ox was suicidal. I don't understand if it hates people. Let's just go with it. It is what it is. So that's Rav's exposition. Rav's a genius. I just don't understand because I'm stupid. All right. The Gemara objects. The ox was subject. If so, the ox was subject to being put to death the very first time that it killed a man in this manner. How could it have remained alive to become a muad? So why do we ask this question? Because, guys, if you remember in 41a, we ruled that kofir is paid only when the animal is a muad. And how can any animal possibly remain alive after killing the first person? Because we said, look, if you remember that the ox actually escapes the courtroom procedure, right? So when it gored somebody, it did it 3 times and kept running to pasture in the field or ducking, or the owner hit it, or whatever the case may be. Tell me something, when it falls in a pit, how's it going to get out? So that's not an option for it. The second option is that the ox wasn't positively identified. Tell me, when the ox is stuck in the pit, can you positively identify it? Yes. Okay. Then do you remember the other case is that the witnesses testified about the first 3 gorings were disqualified through hazama, or they're saying that all the cases came in one go. Well, the cases couldn't have come in one go. Why? Because this would be a subject that people would talk about. The ox is trapped. So how do we explain it? Okay. The only way we explain it is as follows, is that Rav says, Rav Yosef said, okay, we're dealing with an ox that saw vegetation at the lip of a pit and fell into the pit unintentionally while trying to eat it, crushing a person at the bottom. So why is the ox not liable to death? Because his intention wasn't to kill. Its intention wasn't to kill. It happened to kill, but its intention was what? Shame, physical gratification to eat. And therefore, we don't kill an animal that kills somebody through physical gratification. How do we know this? Do you remember we learned at Daf, there was a discussion with Rav and Abaya in 43a. I don't know if you remember, where basically we were talking about a case where for physical gratification, an ox used a member to sodomize a woman or abuse her, and that's how the woman died from internal bleeding or whatever, and that's considered shame. And then we say, well, look, there's a case with Rava and Abaya with regal, where an ox accidentally stepped on a small child. So if you remember, there was a case where Rava said, listen, you only have the death penalty for kofir for keren damage. Why? The animal's intent was to kill. I've often said to you, like in South Africa and Kenya and the British Empire, when lions started to kill people, that killed that animal because it had a taste for human blood. Okay, so that's why the animal was killed. But Shane and regal is a different case. We kill in the case of Shane, but there's no kofir because we don't want to create humiliation to the victim and say, oh, that was a case of sexual immorality. So for the person that either perpetrated the act or was the victim of the ox or sodomy or whatever the case may be, that ox is killed for a different reason, but there's no kofir payment for Shane or regal. Abaya said that there is a kofir payment. Do you remember? So there was an argument between Rav and Abaya. So the bottom line of it is, if it's Shane, we're not even going to go through the Shane part. We're going to call that Rav had to say that this ox intentionally threw itself on people. So the one opinion holds that if it's intentional, it gets the damage. Why? Let's look at kofir. Even when we discussed kofir, we learned that an ox was trying to kill an animal and missed the animal and killed a Jew. We don't put the ox to death. Why? Because it's just like a person that tries to kill an animal and accidentally the animal steps out of the way. He goes to the city of refuge for an accidental killing. So too we treat the ox that's owned by a Jew the same manner. We don't put it to death for an accidental killing. So Rav has to say this ox intended to do this sort of damage and throw itself on people. In other words, for the theory to work. So that's the one case. The other case is that if it's not caring, you don't. There's no kofir. Even in a case of Shane where there's sexual immorality, in that particular case, you'd put the animal to death for a different reason, but there's still no kofir. Why would you put the animal to death? Well, to save the humiliation of the sexual partner of the animal, which is human. Okay? But there's still no kofir payment. The same thing with regal. Abaya said there is kofir for both those cases. And so let's just go through it. It's going to make more sense. Rav Yosef said we are dealing with a case where the ox saw vegetation at the lip of the pit and fell in the pit unintentionally while trying to eat it. And so because it was trying to eat vegetation, there was nothing intentional about its activity. And then it fell in and crushed a man at the bottom. The ox is not liable to death because it killed unintentionally. And we learned this for a Gemara or so ago. Remember when an ox was leaning against the wall to try and get rid of an itch and it crushed a person, knocked over the wall. In that particular case, it's the same. Now, the first 3 times this occurred, the owner is exempt from the kofir payment because his ox is a tam. The 4th time, however, he must pay kofir because it's a muad. Okay, so we say, although the animal falls in unintentionally, one it has done it 3 times, it's deemed a muad because it obviously has a tendency to lean over pits dangerously for the sake of eating vegetation. That's from the Chazon Ish. And it does so consistently even when there's a man in the pit. So basically, according to Rav's explanation, the owner pays kofir even though his ox is not put to death, because the ox in that case is muad. Again, muad deals with habitual behavior. So Rav is saying that, listen, if there's habitual behavior, there's still kofir payment required, but the animal is not put to death because its act was not intentional. But the owner needs to control his animal better. That's why there's kofir. I mean, there's a track record history. There's 3 explanations given. Rav Yosef said we are dealing with a case where the ox saw vegetation at the lip of the pit and fell into the pit unintentionally while trying to eat it, crushing a man at the bottom. The ox is not liable to death because it killed unintentionally. Now, the first 3 times it occurs, the owner is exempt from the kofir because his ox is a tam, but the 4th time he must pay kofir because it's a muad and it shows its habitual nature, so the owner is liable for allowing such a thing to transpire on a regular basis, even though it's not the animal's intention to kill, so it's not put to death. Fine. There's a second explanation. Shmuel said, whose opinion is reflected in this ruling? It's the opinion of Rav Yossi Haglili, who says that the owner of the tam that killed a person pays half kofir, just as the owner of the tam that does monetary damage pays half damages. Okay. So what we are saying is here is that's a different explanation. Most of the Rabbonim hold that you only pay kofir what? If your animal is muad. Rav Yosef Haglili said what? Is that normal damages actions occur of half payment from the body of the attacking animal when your animal is tam. And therefore, kofir is the same. Kofir is the same. There's still half kofir that's you have to pay from the body of the attacking animal. Now, this is the trick. In a case where it's carrying damage, remember there was that term naki, clean, which means that even if the ox escapes and it's not put to death, you're absolved from that kofir payment. That's what most of the Rabbonim say. Okay? Because we have two things. When your ox is caused keren damage and killed a person, how can you pay the half kofir? Because it's paid from the body of the attacking animal, same as damages in the case of damage, and therefore the ox is put to death. So where are you going to pay from? So we're saying, right, in that particular case, there was an argument with Rav Eliezer and Rabbi Akiva. You remember that? Where Rav Eliezer says to Rabbi Akiva, do you think I don't know that the animal's put to death? He was saying, I'm talking in a case where it gets off the hook, the animal, where it technically doesn't get put to death because of those reasons that I explained. It wasn't there at the time of the trial. It hid. The owner hid it. The testimony only came later, etc., etc. And in that case, you need that verse, the owner of the ox is absolved, to say there's no kofir. So clearly, Rav Yossi Aglili doesn't hold like that. Or he might hold like that, but because this is a case of shame, and the animal is not put to death because it's not an intentional killing. So there are those that say for keren, whether it's intentional or unintentional, the animal gets put to death. And there are those rabbis that say it only gets put to death for intentional killing. Okay? But both agree that it never gets put to death for, even if it's muad for shame. Even if it's intentional shame, because his intention wasn't to kill. The question is, does the owner owe kofir? For muad, yes, according to Abai, according to Rava, no. Okay? And because Rava says it's only for death. Kofir is only related to death, not through indirect death. Okay? So according to Abai and many rabbis, for shame, you still have the kofir payment. Why? Because your animal has a habit of killing through shame or regal. But in that particular case, you can pay from the body of the attacking animal. Why can you pay from the body of the attacking animal, guys? The half kofir, according to Rav Yossi Haglili. What's the logic?
Kevin, you want to try? Because he says that the full kofir comes. No, if it's full kofir, then you take the first part from the animal, and the balance you take from choice property.
Okay, that was Rabbi Yehuda. That was Rabbi Yehuda, if you remember. So it's a little different, what you're saying. But Gavin understands the concept. So Gavin's saying very clearly, for when an animal's tum, you pay half payment damages from the body of the attacking animal. That's correct. What Gavin was saying is the tum portion remains in its place, and you only pay, according to Rabbi Yehuda, the muad from choice property over and above that. But if you forget about that and just say there's either tum or muad, so kofir payment would be from choice property, okay, for a muad. For tum, it would be from the body of the attacking animal. It's only possible in the case of shane or regal, because the animal's not put to death. Okay? Otherwise, with what are you going to pay? You can't pay from the body of the attacking animal if the animal's stoned. You can't get benefit from it. There's no hanua. In this case, you can. So Rav Yossi Haglili's opinion would stand, because he was saying that for you pay half payment of for damages, so therefore you pay half kofir. That's his thing. Okay. Now there's a discussion that says there's a third explanation. Ula said the Mishnah is indeed the opinion of Rav Yossi Haglili, but imposes full kofir on the owner of a tam, not half kofir. Why would he say full kofir? Whose opinion does Ula say that Rav Yossi Haglili is following? When do we pay full kofir for a tam?
When a killing after something is after killing.
No, well, there Rav Yossi Haglili said if it's time you only pay half kofir, and the rabbi say you don't pay any kofir. Okay, what we are saying is as follows. Do you remember we did Rabbi Talfon? So Rabbi Talfon is saying this, right? When an animal damages in its tum, in the public domain for keren, what do you pay, guys?
Half.
Half. And in the private domain, what do you pay?
Full.
Yes, because it's trespassing. So here, the case of it is you would pay full kofir because it's happening in the premises of the damaged party. The father and the son own that property. This ox has come to trespass and now has killed them. So therefore, Rav Yossi Aglili's opinion, according to Rav Ula, is saying that there's full kofir damages because there'd be full payment. Yes, because it's in the private domain, correct. Because if it was tam and it injured another animal, it would be full payment damages. And in addition to that, Rabbi Talfon also says that when an animal damages a person, there's full payment damages. Remember that. There's no such thing as tam either. In other words, when it damages another ox, so this is Rabbi Talfon, with people, if it damages in the public domain or the private domain, it's full payment damages. There's no such tam leniency when an ox damages a person, private or public domain. When an ox damages an ox, okay, when an ox damages an ox, in public domain, half payment damages, in the private domain, full payment damages. So here, where a father and a son own the property, for sure, there's full payment damages when that animal trespasses. But even if you would say it's not their property, and even if there's no trespassing, it damaged two people. It actually killed them, so there's full kofir. Does that make sense? Okay, any questions, guys, before I go on?
No, I'm fine.
All right. So let's go on. So basically, the Gemara presents a third explanation for the Mishnah's ruling, according to which the Mishnah means to impose a full kofir payment the first time this act occurs. Why? Ula said the Mishnah is indeed the opinion of Rav Yossi Aglili, but he imposes full kofir on the owner of a tam because he concurs with Rabbi Tarfon, okay, who says that for damage by carrying in the premises of the damaged party, one pays full damages. Here too, where an animal killed a person and generated a kofir payment, and the killing occurred in the premises of the damaged party, the ox's owner pays full kofir. So the Gemara analyzes the various explanations. So all is well according to Ula, that explains that the Mishnah refers specifically to the killing of a person in his own premises. That is why the Mishnah states that the trespasser pays kofir. Specifically in the homeowners is the father or the son that was killed in the cistern. Okay? So what it's saying is, according to Ula, it makes sense why the Gemara is saying the father and the son. Generally, who owns the premises? It would be the father or the son. It's not a stranger. It's not a stranger that came to visit. Because a stranger that visits, it's not his private domain, is it?
No.
So, the Gemara is basically saying that's why the Mishnah states the father and the son. Since the homeowner's father or son by right in his premises is considered a case of death by carrying in the domain of the damaged party for which a full kofir payment is incurred. If the deceased would be someone who did not belong in that domain, the owner of the trespassing ox would be liable only to half kofir, and the Mishnah does not wish to deal with the payment of half kofir. But according to Shmuel, he explains the Mishnah is dealing with half kofir because Shmuel is just talking about Rav Yossi Aglili is basically holding that there's half kofir just for tam, just like the half damages. Shmuel doesn't say that Rav Yossi Aglili is holding like Rabbi Talfon. So we're saying there's a problem. Because why does the Mishnah refer specifically to a case where the falling ox killed the homeowner's father or his son? Even if it was another person, the same law would apply. So what it's saying is, well, there's a problem according to Shmuel's explanation of Rav Yossi Aglili. What's the problem, guys, by logic? What's the problem, guys?
You have to repeat the last part.
Oh, yeah, just repeat it. Yeah.
All right. So we're saying, look, there's no problem according to Ulla, who explains Rav Yossi Aglili, because he's saying the reason why the Gemara mentioned the father or son is that it's their private property. So that's why he said it's mentioning the father and son specifically, because it comes to teach you that there's a proper kofir, full kofir, because Rav Yossi Aglili holds like Rabbi Talfon, Rav Ulla said, which means there's full kofir because it's on the premises, the death is occurring or the damage is occurring on the private premises to those people on those private premises that own it.
And the animal's tum, though, eh?
The animal's tum.
Yes.
So just remember, Rabbi Tafan says two things. That he doesn't distinguish he says on the damaged all damages that occur in private property are full payment, and in public property half payment with regards to an ox scoring an ox. So the saying here is that the Gemara makes sense according to Ulla, explaining Rav Yossi Aglili, who holds by Rabbi Talfon, because the Gemara says if the father and son were killed in a cistern. So what lesson are we learning here? That if it's only the father or the son that was be killed, there'd be full kofir because it's their private domain. But if a trespasser, or maybe for example, somebody was coming to visit the family, like the local plumber, let's call it the local plumber, and he was in the cistern fixing the geyser or the water retention or whatever, the ox came and fell in. Is it his private property, yes or no?
Not his, but surely it's still private property. It doesn't matter.
Mm.
Yes, but yes. So accordingly, I would agree with Gavin that the reason that Rabbi Talfon would say they're full payment damages is the ox doesn't have a right to be there. I agree with Gavin, but here it seems to imply that if it's not the property of the owner of that property. In other words, the ox is a property of the owner of both that ox and the property. So that's what it's implying here, that if the two are not synonymous, then there's not full payment damages. In other words, if somebody came to visit with their ox in the private property, it's like that person is, inverted commas, a stranger, just like the ox that came. But I agree with Gavin. I agree with you.
Maybe he's looking at it that an outsider in your premises is actually in the public domain.
Correct.
In the private.
Correct.
And that's why it's off.
Correct. So it's saying that makes sense according to Ulla, but then how do you explain Rav Shmuel's explanation? How do you explain Shmuel's explanation? Because Shmuel said Rav Yossi Aglili just holds that there's half kofir, just like there are half damages. So why mention in the Gemara the term the father and the son? I mean, why mention them specifically? Just say a person was fixing the cistern and got killed by an ox that fell on him. The very fact that it's mentioning the father and the son has relevance, and that relevance is that because they own the property, it would have to kill somebody that owned the property on their property in order to get full kofir. But if it was a stranger coming to do services rendered, it's half kofir. So how do you explain it according to Shmuel? What do you do with the fact that the term the father and the son was mentioned? Isn't it extraneous? Okay? You understand the question? In other words, it's mentioning the term father and son for a reason. And that's to say that it's the father and the son that own the property. That's why there's full kofir. Because there's a link, as Gavin said, just give me 1 second, there's a link between the owner of the property being damaged or his property being damaged, like his ox, and the person that owns that piece of land. But if it's a stranger that came to visit, it's deemed like the public domain. So therefore, why mention the father and the son? I mean, you don't need to mention it. It's superfluous. You could say anybody in the cistern that got damaged. So we say, how does Shmuel explain this? So Shmuel explains it as follows, is that at the end of the day, the Mishnah teaches its ruling regarding a common case where one who was killed is a relative of the homeowner. So what the Gemara is saying is, look, there's no specificity there. Why? Because they're just mentioning the father and the son just simply because they'd be the most likely ones on their premises, working on the cistern. Okay? There wasn't plumbers.co.za then. There wasn't exactly sewerage going on and complicated infrastructure. So it would generally be the father and the son. So there's no special mention. I just used that because it's most common. And it uses the most common example instead of using the word a person was in the cistern. Guys, I'm holding a little bit different. I've got my own idea here. I just want to tell you. Tell me what you think. Okay. Rabbi Tarfon's got two laws. His first law is as follows. Ox, Kevin, this is important. An ox that is tam damages another ox in the public domain. There's half payment damages. When the ox that is tam damages in a private domain an ox, okay, it's full payment damages. Let's just say that it's whether we say it's any ox, but it's still trespassing on private property, or it has to be the homeowner's ox. It doesn't matter because that's the case of the kol v'chomer with public to private property. But I've got another kol v'chomer as a proof. This is in my head. Could be nonsense. And that is, Kevin, is that Rabbi Tarfon says, of which Rabbi Yossi Aglili holds, is that when an ox attacks an ox, it's half payment for tam. When a tam ox attacks a person, it's full payment, but still from the body of the attacking ox. That's the dayu. So here I'm saying it doesn't matter who's working in the cistern. If the ox fell into the cistern and there would be full payment damages for tam, there would be full kofir damages because it fell on a person, not another ox. That's my guess. What do you think of my theory, guys?
Yeah, no, it makes sense.
It would still make sense, wouldn't it?
Yeah.
Okay.
I think it's a theory, yeah?
Listen, I didn't say it holds water, but I've got a logical base.
The cistern holds water, Damon.
The cistern holds water. That's exactly it. All right, guys, I'm going to send a new link now.
But Damon, just before you send the link, what you said, I was going to say exactly. Because if an outside contractor is working in someone's private cistern, they don't own the property. It's not the owners that got killed. So that's exactly what I was going to say. So you said it.
Yeah, exactly. And we learn there, if you want to apply Rabbi Tarfon's kol v'chomer, if it's full payment damages, if an ox, even in the public domain, guys, in the public domain, injures another person, it's full payment from the attacking animal for a tam ox, then why wouldn't it be here full payment damages even if it's a relative? Because it's still seen as a public domain, but it damaged a person. So why wouldn't there be full kofir if it killed a person? Same rule. All right, go on. The Mishnah concludes, but if he brought his ox into the courtyard with the owner's permission, and it was damaged there, the owner of the courtyard is liable. Rebbe says in all these cases, the homeowner is not liable for damage occurring to property placed in his domain with permission unless he explicitly accepts upon himself the obligation to guard it. So Rebbe is saying that, yes, you can say to the person, you can leave your stuff here, but it's not my responsibility. That's Rebbe's default position. The rabbis say, when he allows him to keep his stuff there, he takes on the role of custodian. Okay? That's the bottom line. So the Gemara disputes a practical halacha. It was stated, Rav said, the halacha follows the Tana Kamma. And Shmuel says, the halacha follows Rebbe. Okay? A related brisa is stated. The rabbis taught in a brisa, if a homeowner tells his fellow, bring your oxen to my premises, and you guard it. The law is that if the ox did damage to the homeowner's property, its owner is liable to pay. And if the ox was damaged there, the homeowner is exempt from liability. Okay? Very clear so far. In other words, Gavin wants to bring his ox into my farm. I say to Gavin, I'll let you into my farm with your ox, but you have to look after it. Okay? Which means if anything happens to it, I'm not liable. And if it does any damage to my stuff, you have to pay. That's the inference, because I told you to guard it. So, if the homeowner says, bring your ox into my premises and I will guard it, the law is that the ox was damaged there, the homeowner is liable to pay. And if the ox did damage to the homeowner's property, its owner of the ox is exempt from liability. Very straightforward, okay? So, the Gemara analyzes this brisa. This is self-contradictory. You say in the first clause that the homeowner says, bring your ox into my premises and guard it. The law is that the ox did damage, its owner of the ox is liable, and if it damaged the homeowner is exempt, okay? Because the homeowner asked the owner of the ox to guard it. We remain firm that the reason for this rule is that the homeowner told his fellow, guard your ox. And it's only in this instance that the ox's owner is liable to pay for damages done by the ox, and the owner of the yard is exempt if the ox damaged there. But in a case where permission to enter is granted, but the matter of guarding is not specified, the yard's owner is liable if the ox damaged, and the ox's owner is exempt if his ox does damage. Because when one grants permission for something to be brought into his domain without specifying the matter of liability, he automatically accepts upon himself the responsibility of guarding the object while it's on his premises. Okay, so whose opinion does this follow, guys?
Whoever's writing the Mishnah.
Well, who is that? Is it the rabbi or the Rebbe? Is it the rabbis, the Tanna Kamma, or is it Rebbe?
The rabbi.
Why?
I've just forgotten what we're talking about. Sorry, I'm just having a bad day. Just give it to me again, the last sentence.
Right.
I'll tell you.
So guys, we're basically saying this, right? That the general default position is that when I allow your ox into my premises, I'm going to guard it. When I use the statement, I want you as the ox's owner to guard it, I'm changing the default position. Okay, but if I hadn't stated that, the default position is that if I hadn't said anything, it's my obligation as the homeowner to guard your ox, so that if any harm comes to your ox, I have to pay for your ox, and it's exempt if it damages anything on my property, unless I state otherwise. So this is the opinion of the rabbis, of the Tanna Kamma. Okay?
But the rabbis, because main one, because they claim that the default position. See, I disagree with the default position. I would have preferred, in my opinion, I would have preferred if the default position was that you don't take responsibility.
Yeah, that's Rebbe.
That's Rebbe. I prefer that.
Yeah. No, that is Rebbe. So listen, there are pros and cons to both, depending on what side of the coin you fall on. So, okay, so that's the opinion of the Tanna Kamma, which generally the Tanna Kamma is the anonymous opinion of the rabbis, meaning it's not a specific rabbi, it's a general rabbinic agreement. Now, consider the Brice's latter clause. If the homeowner says, bring your ox into my premises and I will guard it, the law is that if the ox was damaged, the homeowner is liable to pay, and if it did damage, his owner is exempt of liability. We may infer that the reason for these rules is that the homeowner told the fellow, I will guard it. For it's only in this instance that the yard's owner is liable if the ox damaged, and the ox's owner is exempt if it's done damaged. But in a case where permission to enter is granted, but the matter of guarding is not specified, the ox's owner is liable to pay for damage done by his ox, and the yard's owner is exempt if if the ox damaged, because one who grants permission for something to be brought into his domain without specifying the matter of liability, he does not automatically accept upon himself the responsibility of guarding the object. Okay? This is the opinion, guys, of Rebbe. Okay? It's the opinion of Rebbe. who says that a homeowner has no responsibility for something placed in his domain with permission unless he explicitly accepts upon himself the obligation to guard it. So the Gemara is saying basically the first clause of the brisa follows the rabbis, and the latter clause of the brisa follows Rebbe. So the Gemara responds, Rav Elazar said the brisa, as it appears, is self-contradictory. Whoever taught this ruling did not teach that ruling. The first clause is a quotation of the rabbi's opinion, whereas the latter clause is a quotation of Rebbe's conflicting opinion. Okay, now we've got only a few minutes left, but there is an alternative explanation. Rava says the entire brisa is the opinion of the rabbis, who say that when the homeowner does not specify, he automatically undertakes to guard the object that he permits into his domain. Okay, so the explanation of the latter clause is that since the Bava Kamma, the rabbis deal in the first clause with the case where the homeowner said, guard your ox, this is the only case, it's an exception, because that the visitor is responsible. Okay, because he specifically said to the person, I'm not accepting responsibility. But in the latter clause, the law regarding the opposite case, the homeowner said, I will guard it. Basically, Rava said it doesn't matter whether he stated, I will guard it or not guard it. The default position is, according to the rabbis, that the homeowner accepts responsibility unless he tells the owner of the ox to guard his ox. Even if he didn't say, I would guard it as the homeowner. That's the default law. That's what Rava says. Okay? But Rav Papa has a different opinion. He says the entire brisa is that of Rebbe. He says that the homeowner doesn't assume responsibility for the object unless he states so explicitly. And the explanation of the first clause is that Rebbe holds like Rabbi Talfon, who says that damage for Keren in the premises of the damaged party, one pays full damages. So this is important. Therefore, the following rules apply. With respect to damages by Keren, if the homeowner told his fellow, you may bring in your ox but guard it, he does not convey to the ox's owner the rights to any place in his yard, but retains all rights for himself. Okay? Accordingly, if the visiting ox gores the homeowner's ox, this is damage that occurs in the premises of the damaged party alone. And in accordance with Rabbi Talfon's opinion, damage for Keren in the premises of the damaged party, you have to pay full damages. But if the homeowner didn't say anything, like he didn't tell the visitor, guard your ox, then he actually granted him permission to bring his ox in the yard, and it becomes like a yard of partners, shared partners, because they both have permission to be there, which means if there's any Keren damage, there's half payment damages. But Rebbe does never say a case where the homeowner turns around and says, I will accept responsibility for your ox. He's saying, no, if your ox damages, you still owe me half payment damages. Even though I gave you permission that we got shared rights with regards to this ox, I'm not letting you off the hook. I didn't accept responsibility for no damages paid for damage to my property. You pay me half damages. When I've told you to explicitly look after your ox, you're not even considered like a joint partner in this yard. You have to pay full damages. But there's never a case, Rav Papa said, that Rebbe says that you, as the homeowner, have to accept damages. All right, guys, we're done.